Welcome to Building Your Legacy, Southern Arizona Estate Planning with Allison Manning.
Hello, everyone. Welcome back to Building Your Legacy in Southern Arizona with attorney Allison Manning. Allison is an estate planning attorney who helps individuals and families across Southern Arizona create clear, practical plans for the future. She works closely with clients on wills, trusts, powers of attorney, and long-term care planning, with a focus on making sure those plans actually work when they're needed. I'm Sean O'Connor, and today we're talking about what powers of attorney actually do, when you need them, and how they fit into a complete estate plan. Allison, hi there. How are you?
Hi, Sean. I'm well. Thanks for having me.
Absolutely. Power of attorneys. Can't wait.
Exciting stuff.
Yeah, no, but it's important stuff, that's for sure. Explain to listeners, what is a power of attorney and what does it allow someone to do in Arizona? Because it doesn't let you become an attorney.
That's correct. A power of attorney is a legal document that you as the principal will sign and give authority to a trusted person that's referred to as your agent. This document allows them to act on behalf of you, for items that are within the document terms. So oftentimes you can have a general power of attorney that lists a lot of different powers, or you could have a specific one that just refers to doing one or two tasks on your behalf. This document is valid throughout the state of Arizona. One, so long as it's validly formed, and two, so long as the institutions that are going to accept them, that they like the form and they accept it. So it's actually up to those institutions if they're going to accept them. But it's a very important tool in an estate planning.
Yeah, that's interesting. Well, I think you mentioned a couple. You said general power of attorney and then something specific. Are there must be different types of powers of attorney? Is that right?
There are. There's different types of powers of attorneys, but most of the time we talk about a financial power of attorney where someone can act on your behalf with financial institutions and or the ability to sell like real property, dealing with your assets, entering into contracts. And then there is your healthcare power of attorney, and that's a document that deals with making medical decisions. And so that's something that we look at specifically when we look at the documents, we read them. What powers are they granting? Are they granting something for financial? Are they granting something on your healthcare side?
The institution, let's just say a bank, may not like the power of attorney that they are presented with. It seems to me like, look, it's either a legal document or it's not. What circumstances lead to an institution saying, we're not going to take that?
Sometimes institutions don't take them, one, because we're making the presumption it's a legal document, that it's validly formed. Sometimes the document's not witnessed. Sometimes it's not notarized. Other times it has language they don't like. For example, if somebody used a power of attorney to form a trust, but the power of attorney doesn't expressly state that the agent had the intent to form a trust, a bank may say it didn't expressly say that in here, even if it says you can do all things for me. We need to have that intent to form a trust. And so they may reject the power of attorney. So again, it's a questionable tool. It's an important tool and you still need it, but we want to make sure that you have one that's legally drafted, and that's comprehensive, that covers for various situations. Additionally, we want to make sure that the power of attorney doesn't end upon incapacity. Some documents do. So in estate planning, the reason for the power of attorney is oftentimes to cover for times of incapacity. That would be the term durable, where there are power of attorneys where somebody has the authority to sell a property for them, but it's more under a business setting. And if that principal was to become incapacitated, that power of attorney would end. And oftentimes I have these documents that people have downloaded off the internet and they're not covering for the right situation. So we need to read for the terms of that it continues during a time of incapacity.
What should someone consider, when choosing an agent for a power of attorney?
I like to remind clients when they're choosing their power of attorney is we have to discuss their family dynamics and situation. does it make sense for them to choose their child or their spouse to be their agent? Oftentimes it does. But by picking somebody, is it going to cause conflict with others, the other loved ones in the family? Is somebody really busy in their job and not going to have time to be able to step in and help you out if you need it? Are they trustworthy with finances, if it's for the financial power of attorney? Or on medical side, are they going to be able to pull the plug if necessary? I'll tell you, my mom was my power of attorney for a while, and I went and I talked to her about it, and I said, Mom, you're my medical power of attorney, and if I am incapacitated and there's no hope, go ahead and pull the plug. And she told me she could never pull the plug on me. And so I had to change that and make it my sister, who I knew would be able to pull the plug on me. I joked she'd gladly pull the plug on me,
Right,
but
yeah.
I know that, it would be a very difficult thing, but that she could honor my wishes. And so again, finding that right person, that trusted person that will do the right thing and follow your wishes. Sometimes it's not a family member. Sometimes it's a fiduciary or another paid, another paid representative to be in that capacity for you, because you may not have someone that you trust in that position.
Right. Oh, that's good. That's good advice. Yeah. Someone needs to have sort of the not skill set, but, sort of emotional makeup that, the personal relationship, for better or for worse, makes someone, appropriate for the job. What kinds of decisions can make an agent make? If under a power of attorney, are there? I mean, I know it can't be carte blanche.
Right. So an agent can make the decisions that the document authorizes them to do. So again, it's very general at this point, because I would have to look at the documents to see. But generally, the documents allow for agents to sell real property, to access cash in banks. It can give authorization to access retirement accounts, make elections for life insurance policies. Your power of attorney may give your agent authority to even move money away from you if they're trying to get you on certain types of government benefits, like a Medicaid benefit. Your power of attorney may give authority to create a trust or fund a trust, which means transfer assets into the trust name. And so it really depends on what the document says. And when they can step in also depends on what the document says. Some documents come into effect upon your incapacity, which would be what we call a springing power of attorney. And some documents come into effect immediately upon your execution of the documents. And say for a married couple, it may be a hybrid where it's effective for the spouses immediately, but for the children, it's not until incapacity that they're able to step in.
So what about on the healthcare side? How does the healthcare power of attorney work? When does that get used or not?
Yeah, the healthcare is a little different because, of course, medical providers want to deal with you. They want to respect your autonomy and your ability to make decisions. So the healthcare comes into effect when you're unable to make or communicate those medical decisions on your behalf. And sometimes it's a gray area. Oftentimes doctors may bring your power of attorney in if they're not sure if you're understanding what they're asking in making a medical decision and making it clearly on your behalf. But it's at that point in time when you cannot make or communicate those decisions.
I know we're talking about Arizona, and things differ state to state oftentimes, but in Arizona, if someone becomes incapacitated without a power of attorney, what happens in that scenario?
So if someone doesn't have a power of attorney and they're incapacitated, they have no other estate planning documents, they can be in a pretty tough position. We find ourselves going through what I refer to as the living probate process. And this is where we may have to go through a guardianship to get somebody appointed to be your guardian and make decisions for you, or your conservator to manage your finances. This is a lawsuit where your representative would actually sue you to declare you incapacitated, and they would then step in order to make decisions for you. There has to be a hearing involved, a court investigator, a court-appointed attorney gets appointed for you to defend you and and your rights, because your rights are being taken away at that point in time. And again, without designating who you want to be the actual guardian for you, it's now up to the court to decide who the right person is. Is it your spouse? Is it your child? Is it a fiduciary, a third party? You have lost the say in who should be in charge of making decisions for you while you're alive.
Assuming I'm not incapacitated, I've got the power of attorney in place. Can I change it or revoke it? I'm assuming yes, but I don't know.
Yes, absolutely. You have the authority, so long as you can, to make those changes. You have the ability to designate who your agents are, and you can also modify the authority and the powers that they have to act on your behalf. It's important to review your plan every couple years and make sure that your decision makers and the authorities that you give them are the right decisions that you want to be made, and they're the right people. Along with the medical power of attorney, you also should have a living will, a mental health power of attorney, and a HIPAA authorization. And so looking at all of those together, it gives your medical agent the decisions that you want made on your behalf. And so that's extremely important to make sure that those are up to date and that they're the right people and the right decisions on your behalf for life-sustaining decisions.
Yeah, those are all, I see future episodes talking about all those other factors. The powers of attorney, wills, trusts, other documents or tools, instruments. They kind of, they're all part of an estate plan, which I know, and I know that you're doing estate planning. How do the powers of attorney work alongside these other instruments like wills and trusts?
So I look at your whole estate plan as a big toolbox, and the power of attorney is one of those tools in there. It's a vital tool. If we need a hammer, we're taking a hammer out to hammer in something. But this is the same thing. If we need a power of attorney because my mom is unable to make financial decisions and I need to take that power of attorney out and send it to her financial advisor so that I can make decisions on her investments, I pull that document out. If I need to act on something that's under the trust, then I use my power as the successor trustee to do actions under the trust. And so it's just another one of those tools that's comprehensive. It's not, it shouldn't be acted on its own. It definitely is a part of the whole picture of an estate plan, an important tool, but it is incomplete on its own.
Do clients come in asking for powers of attorney in isolation? I just thought of this, given that you said it's part of a toolbox. Is that something that someone would come to you for as a standalone, or is it really like you really need to do not everything, but you need to approach it comprehensively, I'm guessing?
Clients will come in and say, I need a power of attorney, but many times it's because they don't understand what a power of attorney does. They don't understand that at your death, your power of attorney ends. So there's no actions that can continue on that financial power of attorney. Their rights to access the money ceases when you die. And so now we need a will in order to authorize someone to step in, or we need beneficiary designations on accounts, or we need a trust. And so those all work together in order to make sure that they have a plan, but a lot of people don't know that. And so I'm grateful for this opportunity to share with you and with others that it's not just a power of attorney. That's not enough most of the time. Maybe for an 18-year-old or a 20-year-old, when they first are independent as an adult, they have no assets. Yeah, let's get them some powers of attorneys, and we can deal with the other documents later when they acquire their assets and have a little more estate planning needed. But for the most part, most people need more than just a will.
Understood. Well, we'll talk more in the future. We're kind of up against our time, Allison. Great to see you. Thanks for sharing.
Absolutely. Thanks so much for having me, Sean.
That's it for today's episode of Building Your Legacy in Southern Arizona with Allison Manning. Powers of attorney are often some of the most important documents to have in place before anything happens, especially when it comes to making decisions during your lifetime. But, as Allison said, they're only one one item in a mix of important documents. If you want to learn more, get more guidance on your situation, visit Allison's website at AllisonManningLaw.com. Thanks for listening. I'm Sean O'Connor, and do us a favor, leave a review, share a link, like this episode so you don't miss any in the future. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.